Did you know some things should never go in your will even though many people include them? And it can cause serious legal problems for your family. In this video, we're going to talk about what should never go into your will because some of these items seem like they belong in a will, but the truth is, including them could do real damage. Hi, I'm Dr. Ray Gervasio. In 30 years as an attorney, I've seen families torn apart, wealth drained, and years wasted in court, all because of poor planning. We make sure that doesn't happen. If you want to protect what you've built and keep your family out of court, call us at 408-945-3950. When people sit down to write their wills, they often think of it as a catch-all document, something where you can put every wish, every instruction, and every asset. But that's not how wills are designed to work. A will is a public document that goes through probate. That means every word of it can be scrutinized, challenged, or delayed. Let's go through the 10 things you should keep out of your will and look at better alternatives. Assets that go through probate. One of the biggest mistakes is including assets that are already designed to bypass probate. For example, retirement accounts with designated beneficiaries, bank accounts with payable on death instructions, or property owned jointly with rights of survivorship. These pass automatically to the named person. No court involvement is needed. But if you also include them in your will, it creates a conflict between what the will says and what the account contract says. And legally, the contract wins. That can leave your family confused and possibly fighting over what you really meant. Instead of listing these assets in your will, make sure your beneficiary designations are accurate and up to date. Your business interests. If you own a small business, it's natural to think your will is where you should say who gets it next. But an active business can't just sit in limbo while a court process plays out. If you try to pass a business through your will, operations can stall, employees may leave, and the value of the businesses can quickly drop. Instead, business succession planning should be done outside the will. This might involve a buy-sell agreement, placing the business in a trust, or carefully drafting operating agreements that explain who takes over. Life insurance. Life insurance is another item that doesn't belong in your will. A life insurance policy already has a named beneficiary. If you write something different in your will, it won't matter. Worse, if your estate is the named beneficiary, the payout could be subject to estate taxes and probate delays. The better approach is to name individuals, or sometimes a trust, as the beneficiary so that the money transfers quickly and directly to the right people without unnecessary taxes or legal complications. Joint accounts. Many people have joint bank accounts, especially married couples or elderly parents with adult children helping them manage finances. These accounts automatically belong to the surviving joint owner, no matter what the will says. Including them in your will is not only unnecessary, but can cause disputes. If your will says one thing and the account agreement says another, the bank follows the account agreement. The cleanest way to handle joint accounts is to confirm ownership now and avoid mixing them in your will. Outdated terms in your will. Another trap is outdated instructions. Life changes, such as people marry, divorce, have children, you lose loved ones, or acquire new assets. If your will leaves property to someone who has passed away, or it doesn't account for new family members, the court has to step in to interpret what you meant. That can mean months or even years of delay, plus thousands in legal fees. An outdated will can actually make things harder for your family than if you had no will at all. This is why estate plans should be reviewed regularly, especially after big life events. Putting confidential info in your will. Sometimes people try to be thorough by including things like bank account numbers, PIN codes, or even passwords in their wills. Problem is that wills are public documents once they go through probate. That means anyone can read them, including people you never intended. Putting confidential information like that in a will is basically handing over your security to the public. A better approach is to store sensitive information in a secure place and let your executor or trustee know how to access it safely. Personal and private wishes. Another mistake is using your will to send messages to family members or air out grievances. Remember, wills become public record. If you use your will to criticize, punish, or shame someone, those words could be read in open court. Not only can this hurt family relationships, but it can also fuel challenges to your will. If you have personal matters you want to address, it's better to put them in a private letter, video, or family conversation, not in a legal document that will will outlive you in a courtroom. Passing down personal belongings. Items such as jewelry, collections, or family heirloom often have more emotional value than financial value. Putting them in your will means they'll have to go through probate, which can require appraisals, court oversight, and delays. Meanwhile, family members may be arguing about who gets what. Instead, many people create a separate personal property memorandum or place these items in a trust. This gives you flexibility to update your instructions without rewriting your entire will, and it helps prevent probate from dragging out over something sentimental. Funeral and burial instructions. It may feel natural to put your funeral or burial instructions in your will, but here's the problem. Wills are usually read after the funeral has already happened. That means your instructions could arrive too late. If you want to make sure your wishes are followed, have those conversations directly with family members and put your preferences in a separate document that can be accessed immediately. Leaving major assets to heirs. Finally, leaving major assets directly through your will, like large real estate holdings, significant investment accounts, or business interests, can open the door to probate delays and disputes. Courts move slowly, and if someone contests the will, those assets can be tied up for months or even years. Instead, these assets are often better managed through trust, which transfer property privately and with less chance of a challenge. A trust allows you to keep control while you're alive and ensure that the transition happens smoothly when you're gone. A will is an important document, but it's not the place for everything. Including the wrong items can cause confusion, delays, and even financial losses for the very people you're trying to protect. By keeping assets with beneficiary designations out of your will, avoiding sensitive information, and handling major property or business interests through trust, you make life much easier for your loved ones. If you're worried about whether your current will includes some of these problem areas, the best step you can take is to sit down with an experienced estate planning attorney. They can review your documents, identify issues, and guide you towards safer alternatives that can protect your family. If you're unsure whether your will is set up the right way, haven't started your estate planning yet, or if you need to review your existing plan, give us a call at 408-945-3950. We'll guide you through the process and help you create a plan that fits your needs. And if you found this video helpful, don't forget to hit the like and subscribe. I'll see you in the next video.